My name is Jennifer Simpson, and I'm an attorney with the law firm of Moore Ingram Johnson Steele. My primary area of practice is corporate law with a special focus on intellectual property, namely federal trademark registrations. In the context of representing our corporate clients, we as attorneys often find that a key concept to the client's success is their ownership of intellectual property. Therefore, it is vital to continue their success to provide such property through the process of trademark registration with the United States Patent and Trademark Office. To that end, I will spend the next few minutes talking about not only the importance of such registration, but also the process itself. When a client possesses a valuable trademark, a federal registration is immensely valuable in protecting the client's brand. While obtaining actual registration provides nationwide protection, we always recommend that our clients remain vigilant in enforcing such federal registration in order to prevent trademark infringement. Once a client decides to move forward with the trademark process, we then walk them through the process from start to finish. The first step in registration process is to understand exactly what needs to be protected as a trademark. For example, a client may choose to trademark the name of their business, which is what I refer to as a word mark, or such client may place more value in a stylized design, which is what I refer to as a logo mark. Whether the client chooses to pursue registration of a word mark or a logo mark or a combination thereof, the client will then need to identify the goods and/or services that are provided thereunder. The USPTO provides an extensive identification manual that assists us in advising our clients of the proper goods and/or services for their trademark. Once we arrive at the proper class of goods and services, a specimen showing the mark being used in conjunction with such goods and services is required for the application process. Examples of specimens vary depending upon whether the trademark covers goods or services or a combination thereof. The next step is to then identify whether the client has already begun using the trademark in commerce, which would necessitate a Section 1A actual use application, or whether the client plans to begin using the trademark sometime in the future, which would require a Section 1B intent to use application. There are differences in both the applications themselves as far as their timeline, so this is an important decision for clients to make as to when to begin the registration process. Any relevant dates for usage of the mark, such as the date of first use in commerce, will ultimately be necessary to obtain registration. Finally, once the application is submitted, the USPTO will assign the application to an examining attorney who will review the submission primarily to ensure that no previously existing registered marks would be confusingly similar to the trademark application. Assuming the examining attorney accepts the application as submitted and there are no issues that arise from subsequent publication of the mark, a certificate of registration will ultimately be issued. In my experience as a trademark attorney, I have personally witnessed the extreme benefit building a strong intellectual property portfolio can bring. The benefit of protecting your company's trademark cannot be underestimated. Moore Ingram Johnson Steele, we strive to develop personal relationships with all of our clients. If you or your company has any questions regarding trademark registration process, we here at Moore Ingram Johnson Steele are happy to assist you. Please do not hesitate to give us a call for further information.